Yesterday, a majority of the judges of Trial Chamber 5A of the International Criminal Court vacated the charges against Mr. Ruto and Mr. Sang. The chamber declined to acquit the accused due to the special circumstances of this case. The chamber endorsed the prosecution's position that this case has been severely undermined by witness interference and politicization of the judicial process. The decision noted that other evidence may have been available to the prosecution had it been able to prosecute the case in a different climate, less hostile to the prosecution, its witnesses, and the court in general. The chamber made it clear that their decision is without prejudice to the presumption of innocence or the prosecution bringing the case on the basis of the same charges in the future or in a different form in light of new evidence. We regret that due to deliberate and concerted efforts to derail this case through witness interference, the judges have been prevented from determining the guilt or innocence of the accused on the full merits of the case. The onslaught against this case has, for now, denied the victims of 2007-2008 election violence in Kenya the justice they so rightly deserve. We are currently in the process of carefully assessing the trial chamber's decision to determine the appropriate next steps. The fact is that prosecutions before the ICC can stand or fall on the willingness of witnesses to come forward and tell their story in the courtroom. In this case, 17 witnesses who had agreed to testify against the accused subsequently withdrew their cooperation with the court. Prosecution witnesses were subjected to intimidation, social isolation, and threats to prevent them from testifying. The violence that swept through Kenya following the elections of December 2007 was shocking to all. Neighbors took up arms against neighbors. Kenyans turned on fellow Kenyans. Men, women, and children were burned alive, raped, or hacked to death. Over 1,000 Kenyans were killed, thousands more were injured, and over 200,000 people fled their homes. We decided to initiate an investigation into the post-election violence only when it was clear that the victims of that dreadful violence had no other recourse to justice in Kenya, and their pleas for accountability had fallen on deaf ears. This office engaged in principled and diligent efforts from February 2008 to November 2009 to encourage the Kenyan authorities to fulfill their duty under the Rome Statute to investigate and prosecute those who orchestrated and inflamed the 2007-2008 violence. Although the Kenyan authorities agreed to establish a special tribunal by November 2009, that date came and went. The Rome Statute defines my mission: to combat impunity for the most serious crimes of concern to the international community by investigating and prosecuting those crimes professionally, fairly, and without fear or favor. In this case, we endeavored to identify, secure, and place before the judges evidence that could assist them to determine whether the accused were responsible for the violence that was unleashed on the Kenyans in the Rift Valley following the 2007 elections. Despite our resolve to unveil the truth and advance the cause of justice in Kenya, this case was ultimately eroded by a perfect storm of witness interference and intense politicization of the court's legal mandate and work. There was a relentless campaign to identify individuals who could serve as prosecution witnesses in this case and ensure that they would not testify. This preceded the start of our investigations in Kenya, intensified in the weeks leading up to the beginning of the trial, and continued throughout the life of the case. As a result, potential witnesses told us that they were too afraid to commit to testifying against the accused. Others, who initially gave us accounts of what they saw during the post-election period, subsequently recanted their evidence and declined to continue cooperating with the court. In addition, at public prayer rallies, local politicians and community leaders branded prosecution witnesses as liars who had all given false evidence. On social media, anonymous bloggers engaged in a steady stream of speculation about the identity of protected witnesses. This, then, is the harsh reality that witnesses, and in certain instances their families, faced in this case. Within our mandate and means, we sought to counter interference with the administration of justice in this case by investigating and apprising the Chamber. We obtained from the judges additional protective measures for witnesses. We obtained warrants of arrest for Mr. Walter Osapiri Barasa, Mr. Paul Gicheru, and Mr. Philip Kikoch-Bet on charges of obstructing the course of justice. Yesterday's decision noted that the accused profited from such interference with the administration of justice. We also sought to use creative legal measures to preserve the evidence we had collected. When key witnesses changed their accounts of events, we obtained the assistance of the trial chamber to compel them to appear before the judges so their competing versions of events could be tested before the chamber. When we had collected sufficient evidence to demonstrate that witnesses were recanting their initial accounts because of interference, we applied to the trial chamber to admit the initial evidence of those witnesses under the amended Rule 68 of the Court's Rules of Procedure and Evidence. However, on 12 February 2016, the Appeals Chamber decided to reverse the trial chamber's decision to admit into the record of this case the initial incriminating testimony of witnesses who had been interfered with. Notably, although the Appeals Chamber's ultimate ruling stated that the amended Rule 68 could not be applied retroactively to admit into evidence the initial testimony of witnesses who recanted, it did not reverse the trial chamber's conclusion that there was systematic interference with witnesses in this case. None of the three suspects charged with obstructing the course of justice in this case has been surrendered to the court by the government of Kenya. I call on the authorities of the Republic of Kenya to surrender these three suspects to the court so their guilt or innocence of the charges against them may be determined in a trial. I wish to underscore that this was never a case that targeted a country or a particular community within a country. This was not a case about the collective responsibility of the Kalenjin, Kikuyu, Kisii, Luo, Maasai, or the people of Kenya. This was a case of an individual having to answer to criminal charges brought against him in his personal capacity. In the ordinary course of events, the government of Kenya would have been a critical ally and partner of the office since the case was about crimes committed against Kenyans, crimes prescribed by a treaty ratified by the government of Kenya. As a state party to the Rome Statute, the government of Kenya has both an international and constitutional obligation to assist the office with our investigations. However, despite repeated assurances of cooperation with the court, the government of Kenya provided only selective assistance to the prosecution. The net result is that my office did not have full access to documents and records that may have further shed light to the truth. Ultimately, the hurdles we encountered in our efforts to investigate and prosecute have frustrated the course of justice for the victims in this case. We learned from our setbacks. This office is committed to reviewing, adopting, and improving its working methods. Since I became prosecutor in 2012, we have implemented a series of changes to enhance the effectiveness of our work on the strength of lessons learned. I want to take this opportunity to thank all those who supported the office's work in Kenya. First and foremost, the victims themselves. I thank the witnesses in this case who courageously came forward and testified at great personal cost. I thank all those inside and outside of Kenya, who bravely and tirelessly facilitated and supported our work in Kenya because of their conviction and commitment to the cause of justice. Finally, I wish to thank the states parties to the Rome Statute who cooperated with the office in relation to this case and firmly stood by the principles enshrined in the Rome Statute. During the course of this case, I have been deeply touched and humbled by the extraordinary courage, conviction, and perseverance of so many Kenyans. Notwithstanding the challenges my office has faced in this case, we remain firm in our pursuit of international criminal justice.